In this video, you'll learn from a real-world DUI case how I use the lack of reasonable suspicion to get critical evidence excluded from trial and thereby get the case reduced or dismissed. Here's the facts of this case. A police officer witnesses my client running a red light and then crashing through a road closed sign, entering into a construction area before his truck gets lodged on top of a water main.
What's up, man? Hey, so what happened? Like, how'd you end up how you're at right now?
Well, this guy...
So you're going the wrong way, you hit some cones, and you ended up here?
Right.
Were you just driving, like, straight down the construction site? Is that what was happening?
Yeah, I was coming the wrong way. I came the wrong way.
Okay. And then you just hit this line and you stopped right here?
Yeah.
Okay. I'm going to get you out of the car.
You can get out on that side. We're just going to have to make sure it doesn't fall.
I don't want you to fall in the ditch, so I'm going to walk. Alright, hop out for me.
The driver is detained for a DUI investigation. He performs poorly on the roadside sobriety exercises and is arrested for DUI and blows over the legal limit.
Alright, so I'm now concluding the crash investigation.
Okay.
Alright. From this point on, I'm going to start a DUI investigation. Okay? Because based on what I see, you have red bloodshot eyes, you're slurring speech. Okay, when you stepped out of the vehicle, you were staggering in a way.
Well, I take medicine.
Okay, place your left foot on the line and put your right heel against the toe of your left foot. Okay?
This line right here.
So this line right here.
So demonstrate for him.
Got a step. 1, 2, 3, 4, all the way to 9. You ready now? Start the test.
1, 2, 3.
So those counts as miss. He just stepped off the line. Make sure you're making notes on the card. He just raised his arms for balance. Missed. Missed. Alright, he did the turn right. He's been raising his arms. That's off the line. Miss. Miss on 3. Oh, okay. Yep, no worries. Just try and get back to the line. Just totally stumbled and used his arms for balance. Knees bothering you? Okay. If it hurts, you can stop. Okay, 4 is off the line. 5 miss, 6 miss, 7 miss, 8's a miss, 9's a miss. All right, perfect. You can stop. You just go ahead and place both your hands behind your back. Put them together like you're praying.
No alcohol. I mean, I haven't been drinking.
All right, sir. So you're placed under arrest for driving on the influence of alcohol.
Before we get into the legal analysis of this particular case, let's make sure we're all on the same page with understanding the legal authority of a police officer to detain and to arrest. In order to detain someone, a police officer must have reasonable suspicion that the person has committed a violation of the law. Reasonable suspicion is facts and circumstances within the officer's knowledge to believe that a person committed the offense. If we think about this concept in degrees of certainty, reasonable suspicion has a very low bar. It's more than a hunch, but less than probable cause. If a police officer detains someone without reasonable suspicion of criminal activity, that detention is not lawful. In the academy, recruits are trained to identify and articulate reasonable suspicion and probable cause. Once they hit the road as police officers, they use these concepts every single day. Probable cause and reasonable suspicion are ingrained into the way the police officers think and the way they solve problems. If an officer conducts an unlawful detention or an unlawful search, that evidence is subject to exclusion. Evidence seized as a result of an unlawful detention must be further analyzed to determine whether that evidence will be used against the defendant in trial. There's 3 legal theories the courts will apply when determining whether the evidence is admissible or it will be excluded. Under the exclusionary rule, evidence seized as a result of an unlawful detention will be excluded. If, however, the officer would have discovered the evidence, regardless of the unlawful detention, that evidence will likely be admissible under the theory of inevitable discovery. Similarly, if the officer was in good faith reliance on then existing law and the law has since changed, that evidence would likely be admissible. To detain someone in Florida for a DUI investigation, the officer must have reasonable articulable suspicion that the person was driving or in actual physical control of a vehicle, that the offense occurred within the state, either on public or private property, and that when the offense occurred, the person was under the influence of alcohol or a controlled substance. In the case at hand, it's the state's position that the defendant was involved in a traffic accident and he was required to remain at the scene of the traffic accident while the officer investigated. During that investigation, while standing outside the vehicle, the officer observed the odor of alcohol, slurred speech, red watery eyes, and stumbling.
In the direct examination, you said you mentioned the odor of alcohol in addition to his eyes and slurred speech and stumbling out of the car. You make no mention of the odor of alcohol in your body cam at all. Is there a reason for that?
No.
And when you summarize the arrest of your body camera, you only say you said the eyes and the slurred speech, and your partner says he smelled the odor of alcohol. Do you recall that?
I can't directly recall that, no.
So now today, your testimony is when he got out of the truck and you were engaging with him out of the vehicle, that's when you smelled the odor of alcohol?
Yes.
All right, where at? At what point?
Once he was sat down on the barrier.
Okay, and you're going by what was on your body camera?
I'm just going off my personal recollection.
Okay, that's fine. Let's go to your observations with regards to leading up to the DUI investigation. I believe you had eyes, speech, and stumble, and we talked about odor already, so I'm not discounting that. I'm not going to bring that up anymore because we already talked about it.
Oh.
So let's talk about the eyes. At what point in time did you notice he had bloodshot, watery eyes?
Once he was out of the vehicle.
Okay, so the observation was made out of the vehicle when he was sitting down as well?
Correct.
This solidifies the state's position that these observations were made while the defendant was lawfully detained and therefore admissible. If those observations are admissible, the police officer is allowed to extend the detention of the defendant for the purposes of conducting the DUI investigation. Here's the twist. The officer that conducted the crash investigation and made the DUI arrest was not the first officer on scene. He did not know how the vehicle got into the construction area because he never interviewed the witness officer.
This vehicle, where you found it, was fully encased, enveloped within a blocked off construction zone, correct?
Correct.
And the entrance to the construction zone, you don't know how far of a ways down.
Correct.
Did you ever, or anyone else, ever take your patrol car onto the inside of the construction zone where his vehicle was?
No.
Do you know where you would have even done that?
No.
Okay. So generally, no other motoring public was there driving inside where his vehicle was, correct?
No.
This is significant because the Florida statute that authorizes police officers to enforce traffic laws and conduct crash investigations limits that authority to places where the public has a right to travel or where a private contractual agreement exists. It's the defense's position that based upon this statute, the police officer did not have the right to conduct a crash investigation because the public does not have a right to travel within a construction area. When the officer ordered the defendant to exit the vehicle, the only observation the officer had made at that point in time was slurred speech. That is not sufficient to have someone exit the vehicle to conduct a DUI investigation. Under the exclusionary rule, all the evidence derived from an unlawful detention, including the odor of alcohol, the stumbling, the performance on the field sobriety exercises, and the breath test results should all be excluded. The judge followed the law and agreed with the defense in excluding all of the evidence obtained after the unlawful detention. The judge's ruling does not dismiss the case. Technically, the state of Florida could still proceed to jury trial against the defendant for DUI, but their evidence would be limited to the point of time the officer ordered my client to exit the vehicle. Hit it hard.